Shared parenting is put front and center in today's ruling, and for the first time, the appellate court has sort of clarified when a case may be automatically disqualified from considering 50-50 parenting time. Now, I'll get to that breakdown in just a moment, but first, it's kind of important to address the elephant in the room, which is I was the attorney for the appellant. Now, this isn't the first time I've done a commentary on a case I was involved in. Longtime viewers may recall the SIJS case where the 2nd District found in favor of my client and reversed the trial court's denial of a finding for special immigrant juvenile status. However, unlike that case, litigation is ongoing here, so I'm only going to stick to the two competing legal theories in today's opinion, whether or not 50-50 parenting time makes sense in high conflict cases. And with that said, let's dive into this very unique opinion. Now, if you're new to this channel, I'm going to kind of back up here and explain how case law operates in Illinois. So excuse the cruddy animation, but it's the best I could do. When a judge enters a ruling, it's not binding on other cases. But, and there's always a but, if you appeal, like we did here, and the appellate court enters a ruling, that ruling is binding on all cases in the district it was entered in. Now, we have 5 districts in Illinois. Sometimes one district will have a ruling that's different than another. We call that a split authority. But if no other district has a different holding, then that opinion is good law throughout all of Illinois. Okay, with that said, I've returned to our regularly scheduled program. 50-50 parenting time is a polarizing issue. Reform organizations sort of treat it like a mythical elixir that's going to cure all their family law problems, while opponents feel it's really only realistic in low conflict cases. To be clear, today's holding doesn't prohibit a judge from awarding 50-50 time, but it does set boundaries on when you shouldn't. First, let's begin with Justice Litton's dissent. Now, this is my take on his analysis. Your mileage may vary, but he makes a passionate case that a judge needs to have 50-50 as one of their tools to resolve high conflict cases. That if both parents can't agree on what color the sky is, awarding one the crown will only lead to that parent cutting the other out of the equation, such as changing schools, moving, enrolling the kids in activities that fall squarely on the other parent's time, not notifying the other of appointments, and so forth. By forcing 50-50 into those cases, the dissent suggests it acts as a check against the misuse of power that the custodial parent may inevitably use, and although it isn't the most ideal situation, it may be the best way to limit parental alienation. Now, contrasting that is the majority opinion, which is the holding and likely law of the land until a better case comes out. First, the 3rd District does not shy away from it. They clearly state that they are not big fans of 50-50 cases in contested matters that required a custody trial because settlement wasn't, for whatever reason, possible. Now, just because you're going to trial, that doesn't mean 50-50 is off the table, so long as the acrimony does not impact the parties' ability to cooperate. Or better put, the judge has to look at the case and determine whether the parties can cooperate. If they can't, 50-50 isn't something that's looked on favorably. And as a matter of fact, one of the arguments I stressed in my appellate brief was factor number 13, the parties' ability to cooperate. And I cited case law that suggested it could be the most important factor a judge is to consider. So translated in English, in custody fights, you must check your emotions at the door. If she's 5 minutes late for pickup or drop off, don't start yelling the moment she pulls up. If he sends you an inappropriate or demeaning text message at 2 a.m., ignore it. If you get in the mud to wrestle with the pig, both of you are going to get dirty, and it's going to make my job a lot more expensive. And as case law here indicates, far more difficult. So going forward, if you're seeking 50-50 in Illinois, case law suggests you have to kind of cool your jets. If the judge feels the situation is too high conflict, a generous parenting schedule is likely off the table under today's holding. Now, you may be asking, hey, David, well, what makes something high conflict? And I suspect that's going to be a fact-specific question. How can you prevent a case from going high conflict? Well, I admit, you can't control what your ex does, but you can control how you react. And I would argue to trigger today's holding, it's going to take 2 to tango. In closing, I think anyone who's interested in establishing or modifying parenting schedules that involve significant time sharing needs to read this case, because going forward, it's going to be difficult to force a 50-50 in situations where the parties are unable to cooperate. Anyways, that's all I have. Thanks for watching.